Hi, my name is Christina Loback, and I'm an immigration lawyer at Sisu Legal Immigration. Today, let's talk about a super important rule to know if you are submitting a marriage-based green card application via adjustment of status. It's called the 90-day rule. Before we can really dive into the 90-day rule, though, I just want to make sure that you understand the difference between immigrant and non-immigrant visas. When we talk about immigrant visas, we are talking about permanent resident status or green cards. People who apply for immigrant visas have the intention of permanently relocating to the United States. By contrast, people who apply for non-immigrant visas have the specific intention of entering the United States only temporarily. Examples of non-immigrant visas include visitors, students, and many work visas such as TN status. People who hold a non-immigrant visa are not allowed to come to the U.S. with the intention of remaining there permanently unless they hold what's known as a dual intent visa, like an H-1B or an L visa. The 90-day rule highly scrutinizes the difference between immigrant and non-immigrant visa intent. It states that any alien who engages in conduct inconsistent with their non-immigrant status within a 90-day period of entering the United States may become inadmissible for a green card or even permanently barred from entering the U.S. Essentially, it's a fraud detection tool used to help USCIS determine whether the green card applicant misled government officers when they were granted a visa or admitted entry into the U.S. It's important to know that non-immigrant visa holders are allowed to change their mind once they are in the United States, which usually means marrying and applying for a green card, so long as they genuinely came to the U.S. with the original intention of leaving. But how do you prove that? That's the reason why the 90-day rule exists. It gives officers concrete guidelines for assessing the situation. So, how do officers assess the 90-day rule? If, during the first 90 days of their stay in the U.S., a single intent non-immigrant visa holder enters into a marriage with a U.S. citizen or green card holder, or files an adjustment of status green card application, they could be judged to have misrepresented their original intentions when applying for a visa or entering the U.S. Misrepresentation is the presumption, but it can be rebutted with strong evidence to the contrary. That being said, why go through the uphill battle and struggle of trying to overcome this presumption when you can just wait 90 days to marry and adjust status? It's also important to note that if you are applying through the consular process, you can have your wedding in the U.S. and not worry about the 90-day rule. You will have to leave the U.S. after the wedding anyways and apply for a visa from abroad in that scenario. For more information on our marriage-based green card services, please visit our website or schedule a strategy session with one of our lawyers.